Welcome, everyone. Welcome. It's an honor for me to be chairing today's webinar. I'm Conway Blake, a trustee of the Human Dignity Trust. And on behalf of the Trust, I want to extend a very warm welcome to you all on this webinar. Today, we're going to be discussing the very great occasion of the issuance of the Inter-American Commission's decision in the case of Henry and Edwards versus Jamaica. And here today, I'm joined by a very eminent list of panelists who have over the last decade been working very assiduously and patiently to this point. The Human Dignity Trust has been working with activists, lawyers, and many well-wishers over the past decade to bring this case along with Gareth and activists and Simone from Jamaica working hand in hand to what we all must say is a very commendable and very momentous occasion. Just by way of background, I want to just introduce the Trust. The Human Dignity Trust is an international human rights organization, a very unique organization which primarily lends technical legal assistance to activists, lawyers, and governments all over the world with the aim of challenging and changing laws which criminalize and discriminate against LGBT individuals. We work in all regions of the world to support decriminalization as well as related legal issues. And HDT, as I've said, has been supporting this case at the Inter-American Commission since 2011. The case is actually one of the first cases that was brought and worked on by the Human Dignity Trust over a decade ago when it was started. And while the Trust is here hosting this seminar, this webinar, it is not to suggest in any way that it is the Trust's work. Actually, it's the work of hundreds of individuals over the years. We want to first highlight a number of individuals who have worked tirelessly with us, with Gareth, with Simone over the years to come to this point. First, the Trust would like to really acknowledge the work of Freshfields Brockhouse Derringer, or pro bono law firm partner, who has given very tirelessly and generously of lawyer time and effort and resources to work with us for 10 years on this case. I am told that over 60 Freshfields lawyers over the years have worked on the case. And incidentally, I am one of them. 10 years ago, when I was starting out as a trainee at Freshfields, I worked really closely with the team there on the beginnings of this case, and I'm quite pleased to be able to see it on this end as trustee of the Trust. And just so I highlight the contributions of those at Freshfields, we want to give a very warm thanks to Andrew Austin, the partner at Freshfields, who really from the beginning spearheaded this work, and other partners and lawyers at Freshfields, such as Kate Gow, Maddie Wall, and others currently on the call and who will invariably watch this and be updated. But to be clear, the success of the case is really a testament to Gareth and Simone's bravery and determination and very visionary work in leading local LGBT organizations, including JFLAG, and the hard work of the team in this regard. I also want to give special thanks to the council team, the barristers who helped and worked alongside Freshfields, HDT, Gareth, and other activists and Simone involved, including Mr. Douglas Mendes, Senior Counsel, and Edward Fitzgerald QC from Doughty Street, Professor Bill Balba, and Monica Firatinta from 20 Essex. I mean, the list of individuals involved in this case would take a whole day to enumerate, but we just want to give a very, very, very deep vote of thanks to all of you and to funders and those who are in the background cheering us on and providing support, whether it's material, whether it's emotional, whether it's in terms of legal skills. We want to give a huge thank you. So today's panel is comprised of Mr. Gareth Henry, who of course is the petitioner, one of the petitioners in the case. I'm also joined by Ms. Tia Braun, who is the legal director of the Human Dignity Trust, and Glenroy Murray from JFLAG in Jamaica. Let me just give you a little bit more background on these three individuals. Of course, Gareth is one of the petitioners along with Simone, and he was former director of JFLAG and is now the executive director of the Black Coalition for AIDS Prevention and a senior case officer for the Rainbow Railroad. Did I get that right, Gareth?
Yes, yes.
Tia is the director of the Human Dignity Trust, which represented Gareth and Simone throughout the case. Tia's expertise are in the area of international human rights law and comparative constitutional law. And for almost a decade, she has been working with the Trust on strategic litigation around the world to defend the rights of LGBT individuals, including in Jamaica and other countries in the Commonwealth, Caribbean, Asia, and elsewhere, far-flung places. And hopefully at some point, Tia will be able to share with others who are interested on this call about the very great work that the Trust is doing in many jurisdictions around the world. And last but not least, we're joined by Glenroy Murray. Now, Glenroy is a social justice and human rights advocate with a specific focus on LGBT rights, women's rights, youth development in Jamaica. He acts as the current director of strategy and impact at JFLAG, and he tutors constitutional law and criminal law at the University of the West Indies, Mona campus in Jamaica. And so I will just want to make a few remarks on the case. As I said, this is a very, very momentous decision, obviously for those activists and individuals who are personally affected by the case, but also for the broader international legal community who have looked on to see how this case will build the growing jurisprudence in the area of LGBT rights throughout the world. I'm not going to steal Tia's thunder, and so perhaps I'll leave my observations for when we have the question and answer. As for next steps, we're going to be hearing from each of our panelists, starting with Gareth, then Tia and Glenroy, who will be speaking for 10 minutes each. And then afterwards, we're going to be opening up the floor for questions from participants, and hopefully we can have an interactive and very fruitful discussion. Without further ado, I'm going to open the floor to Gareth to join us and to speak about his personal journey in this case and his personal reactions to the decision of the Inter-American Commission.
Thank you, Conway. And well, that was good day, everyone. I'm trying to figure again with all the varying time zones possible on this call. I'll be saying good morning, but for the folks in the UK, that's afternoon, and elsewhere it might be something else. So, good day. And I'm happy and honored that you all are taking the time to be a part of this today. And for me, my journey with this petition, my work with the and experience with the Human Dignity Trust started almost a decade ago, when I flew to London to talk about my challenges and talk about the possible opportunities to do something to challenge the Jamaican government to become more responsive to the plight of queer folks, LGBTQ folks in Jamaica. Part of my personal journey have, for the most of it, since I took the lead at JFLAG in 2004, have put me in what I would say the firing line from the state, particularly the police, where I have endured severe human rights violation of where I have been the victim of homophobic violence by the hands of the state, been beaten by police officers in front of mobs, waking up in the mornings from my apartment with police officers pointing their guns at me and demanding that I leave. And also, I experiencing and seeing my friends being beaten and being killed and feeling hopeless, that, that there's very little that I can do or can be done to really address the situation that is happening to LGBT folks. And as I do my work and I engage and try to support my community in the best way possible, as I led JFlag at that point in time, we keep coming up on roadblocks, and those roadblocks are, the government's sentiments around the fact that the work that JFlag is doing is, we do not recognize, all the pieces that in terms of what we're saying or talking about Jamaica, it does not exist, it's not the reality. And even though we're able to show, the numbers or the persons who I have accompanied to the police station and all the instances of situations where people have been chased through the streets, been lynched and been killed, it's oftentimes downplayed and not getting the attention that it's supposed to get. And there's so many lives that have been lost over the years, so many, and it's too many, right? And so this petition was an avenue for me to take things on a different level and to seek to bring again greater attention to the issues affecting my brothers and sisters. And so I was honored when the Human Dignity Trust decided to work with me and provided me with that support to bring this petition forward. And I'm also happy that as Simone, who is not able to join us today, was also willing to share her story of, as someone is a person who I work with and someone who I know personally, knew her brothers, and lost a kidney, was shot and left to die. She and her brother at their home, and when they try to get recourse, it again often is that there was no response, there was no support. And the lead up to me, when after I filed this petition, happy to do so in 2012, things with the hope that not anticipating that this would have taken so long, but with these processes, so who knows, that my life consistently changed, and pieces within my life often change because of the decisions that I've made, and because of my activism. My mom, who became the victim of violence because she supported her gay son, who is an activist. And when I fled to Canada in January 2008 to seek refugee protection, my mother had to leave Jamaica the April of that said year and came to Canada because she chose to love her son, as any mother and any good parent would do, is to support your child and be there for your child regardless of. And she too was granted conventional refugee protection in Canada because of being a supportive mom to a gay activist. And when I filed this petition in 2012, I didn't expect anything to happen from this, but my sister, who again has been very vocal and been very supportive of me, became a target of violence. And my two nieces at that point in time, they were 5 and 10 years old, were bullied in school because they had a gay uncle. My sister, who worked as a midwife at the hospitals, there were mothers who go in to deliver who just didn't want her to touch them because of it's as if the support that she gave to her gay brother would be immediately transferred to their newborn child, right? There were signs left at her house. There were threats that she received, and unfortunately, is that she had to uproot her life and the life of my two nieces and move to Canada. And I will forever be grateful to the Canadian government and the people of Canada, because she and my two nieces were granted conventional refugee protection on the merit that they have been supportive of a gay rights activist. And as I sat and wait on this petition, the decision on this petition, through my work with Rainbow Railroad, we have supported over 400 Jamaicans to flee and to seek refugee protection across Europe, North America. This shouldn't happen. We have lost quite a number of persons have been brutally killed because of their sexual orientation, and nothing happens, nothing changed. And many of these hate crimes go unnoticed because they do not get the attention that they need. The police oftentimes report them as crime of passion, even when someone is chased through the street. I remember a young man, Nokia Cowan, who was chased by a mob on the busy street at downtown Kingston, and he reached the front of the harbor, and there was a crowd behind him, over about 300-400 people, women, men, children, chasing Nokia. Nokia was, I think, 22 years old. And what he was confronted with was either to jump into the sea or to be beaten by this mob. And he jumped. He couldn't swim. And that crowd stood and watched him drown. And when I think about, all of this, so many lives being lost and taken because our government have not been responsive and been supportive. And then they publicly speak of the fact that, Jamaica is this wonderful and great place and this paradise where this violence that we speak about and this violence that we experience does not exist. And it's just sad. And I'm just happy that, whilst the recommendations in this petition and the findings from the court is not binding on the Jamaican government, what it does, though, it highlights and the struggles of the LGBT community, and also create an opportunity for greater dialogue on the international scene, and to be able to see how best we can hold Jamaica accountable to protecting the basic human rights of LGBTQ folks. And every time that I talk about my story and my journey, I get overwhelmed because it's painful, because no person should have to leave home because they're deemed to be different by their state. No person should seek, should need to be in need of getting refugee protection in a foreign country, a place where they don't know. Because when I moved to Canada, I have no family there. I was on my own. And this is also a story and the experience of countless LGBTQ folks who traverse the world right now, fleeing for their lives, choosing to have an opportunity, a second chance in life, because Jamaica, their home, is not able to afford that to them. And that is unfair. And that is sad. And, and so getting this ruling, really, for me is a ray of hope that, one, it's documented, it's there, it's coming from an international body. It's not a biased opinion because, this is Gareth that is saying this on Simone, but it's something, due diligence was done in verifying and validating my claim to be able to say the Jamaican state did Simone and I wrong. And I just wish and hope that as we have this report in front of us, that J-Flag will be challenged to do more, to become more, to take this and use this information to engage with the political leaders there, other international organizations that advocate for human rights, LGBTQ, also making sure that this does not, it doesn't die. It doesn't, we have this and we have a conversation about this now, and then, end of the year, it becomes just a reference and no work has been done. I'm committed to do my part and to continue to be involved. Hence the reason why I got involved with Rainbow Railroad. And migration doesn't solve the situation in Jamaica. Whilst through my work at Rainbow Railroad, we have moved, I said, since 2009, we have moved over 400 LGBTQ persons. That's a lot, and that's too many. People, women, lesbians who have been raped, trans persons who have been chopped. Some persons are living with severe deformities. Some of our persons who have worked with are blind because their eyes were poked out. Kids, 18-year-old, 17-year-old, been set ablaze by their parents, live with, right now, I know three persons we have helped who have over 60% of their body is burnt because their father thought that, no, I don't want a gay son, and set his son afire, ablaze while he slept. A change, will come, and a change has to come. But it's just sad that as we wait on that real change, that more persons are going to lose their lives. More persons going to live with the scars of standing up and defending themselves for being LGBTQ. And it just feels hopeless at times. And so when when the announcement was made, I was happy. I felt good that, for the first time, as I said, in a while, that I am empowered to continue to do this, having this information that, I was able to use my experience to support the cause and to also to give hope to my brothers and sisters. I will ever be grateful and thankful to the Human Dignity Trust, all the other persons who have been involved and been supportive of me and through my journey. But more so, I reflect on the lives lost, but also, being able to celebrate the fact that, I am in a safer place, and I wish that this could be the experience of all LGBTQ folks in Jamaica, and this is their birthright. It's supposed to be this. We're supposed to be able to just live free from fear that we're going to be chased through the streets or we're going to be killed, right? We should be able to do that on a daily basis, and I just ask how many more LGBTQ folks, individuals, must die before Jamaica realize that the motto, out of many one people, that we are part of that we are all Jamaicans, and we are deserving to live in dignity and respect, and not to be lynched because we're deemed to be different. And so, I just want to say that there's hope, and I am anticipating and looking for greater collaboration with activists in Jamaica, across the region and internationally, to continue to put this pressure on Jamaica. Something has to change, and something just have to change. It can't be status quo as is, and I'm anticipating and really waiting to see what the Jamaican government response is going to be to these recommendations. Because then that will be the starting point. And their silence, if they remain silent, they would have continued to speak in the same language, and same message that they've been speaking for decades. And so a change will come. I'm hoping for that. Thanks. Thank you. I see Conway saying I need to cut. Thanks. Go ahead.
Thank you very much, Gareth, for that very personal reaction to the decision. And I think what resonates, at least for me, is the fact that while this is clearly a legal win, there are human lives, human experiences, which are the basis of the decision and this petition, and who will be affected, hopefully, by it positively in the future. I want to move now to Taya, who will talk a bit more about the decision and what was decided, and about the legal aspects of the Inter-Americans' response to Gareth's petition.
Thank you, Conway, and hello to everyone. And thanks to Gareth for sharing your very personal and powerful story. I'm going to very briefly summarize what this case challenged, the key moments in the case over almost 10 years, what the findings are and the recommendations, and what the impact is. And I'll be happy to go into any more detail in the Q&A if needed. So Gareth and Simone's case challenged 3 sections of Jamaica's 1864 Offences Against the Person Act, which was inherited directly from Britain in colonial times. For anyone who's not familiar with those provisions, which are still on the books today, provide in section 76 that, which is called unnatural crime, that whoever shall be convicted of the abominable crime of buggery shall be imprisoned for up to 10 years with hard labor. In section 77, that whoever attempts to commit the said abominable crime shall be liable to imprisonment for up to 7 years with or without hard labor. And in section 79, called outrages on decency, that any male person in public or private who commits any act of gross indecency with another male person is liable up to 2 years imprisonment with or without hard labor. Another key legal provision that was an issue in the case is a provision in the Constitution of Jamaica, which has what's called a savings law clause. And that provides that any sexual offense laws that pre-existed the 2011 amendment to the Constitution that contains the human rights provisions shall not be held to be inconsistent with or in contravention of those human rights provisions. So it's a sort of shielding provision that prevents the courts from declaring these buggery and gross indecency laws as a violation of human rights protections. So because of that provision, Gareth and Simone's case argued that there was a lack of domestic remedies in Jamaica to challenge the constitutionality of the buggery and gross indecency laws, such that they could go directly to the Inter-American Commission to seek justice. So those are the key legal provisions in question in the case. Importantly, and this is a first in any case on decriminalization anywhere in the world, the case argued that the buggery and gross indecency laws, while technically only criminalizing male same-sex conduct and not female same-sex conduct, are a direct violation not only of the human rights of gay or bisexual men or trans women who would be captured by it, but of all members of the LGBT community, including lesbian and bisexual women. So it's the first case anywhere in the world that has included a lesbian claimant and which sought to recognize the impact of these laws on women, as well as other members of the community. So that's another reason this decision is historic globally. And that's a really important point. We know that these laws are today used much less often to prosecute men for the alleged offense, and much, much more often to stigmatize, harass, discriminate against, and justify violence, as Gareth has outlined, against anyone who identifies or is presumed to be LGBT. So Gareth and Simone formed a formidable team, and I want to expressly acknowledge Gareth for his complete and unwavering support for Simone joining the case in order to make that important legal point. You've heard about the horrific treatment that Gareth and his family received in Jamaica, forcing them to flee. And as Gareth alluded to, Simone similarly, she was shot twice in the kind of anti-LGBT community violence that the buggery and gross indecency laws incite. And she was separated from her young daughter for years while she sought asylum in Europe to escape the violence. I'm happy to say they're both now thriving. So very quickly, in terms of the chronology of the case, it was filed in December of 2011 by Gareth with the Inter-American Commission on Human Rights. In January of 2014, Jamaica first submitted an initial response, only addressing the admissibility of the petition, not the merits of the substance of the case. It was arguing that the case was not admissible at the commission for numerous reasons, including that Gareth had not exhausted domestic remedies. Later that year, in October of 2014, Simone Edwards was introduced to the petition as a new victim in the case, and Gareth submitted a response to Jamaica's observations on admissibility, arguing that there were no effective domestic remedies available to him in Jamaica. And then on the 2nd of July, 2018, so over 6.5 years after the case was filed, the commission found the petition admissible, meaning that the petition could then move on to the merits stage. And it was relatively quickly after that, just over a year after that, the 28th of September 2019, that the commission issued its preliminary report on the merits, finding in favor of Gareth and Simone. So that is the date that we all knew we had won the case. However, by the commission's rules, the decision was strictly confidential until the commission itself decided to make it public, which we would have to wait patiently for almost another 1.5 years. And that was just to enable a period for Jamaica to respond, which it did with some procedural challenges. All of that is normal procedure. And of course, we respected the Commission's embargo on publication of the decision. Almost exactly a year later, the 14th of September 2020, the Commission issued its final report on the merits, which is identical in all material respects to the September 2019 preliminary report, except that it addresses Jamaica's procedural objections, which it rejects in full. But it was still confidential, as the parties were then given a few months to submit information on the extent to which Jamaica had complied with the Commission's recommendations. Gareth and Simone submitted their observations on Jamaica's non-compliance with the Commission's recommendations in November of 2020. And then finally, on the 31st of December of 2020, the Commission, considering all of the submissions from all of the parties, decided to make its decision public. But that was not communicated to the parties until the 17th of February of this year, when we received the letter from the Commission announcing that they had made the decision public and therefore finally lifting the embargo. So the decision itself dates back to September 2019, but it's only now public. And I thank everyone involved, and most notably Gareth, Simone, and JFlag for their patience and professionalism in respecting that confidentiality order, which must have been very difficult indeed. In terms of the key findings of the case, the Commission found that Jamaica, by retaining those buggery and gross indecency laws that I mentioned earlier, has violated a number of Gareth and Simone's rights under the American Convention on Human Rights. Firstly, the Article 11 right not to be subjected to arbitrary or abusive interference with one's private life, and the Article 24 right to equal protection of the law without discrimination. And the Commission found that these laws, the buggery and gross indecency laws, constitute a restriction on private life that have a disproportionate impact on LGBTI people in Jamaica and that violate equal protection of the law. And importantly, as I mentioned a moment ago, despite none of the criminal provisions capturing sexual conduct between women, the Commission accepted our arguments that the homophobia generated and perpetuated by the buggery and gross indecency laws also put women in the LGBTI community at direct risk of stigma and abuse. The second cluster of findings is on the Article 5 right to have one's physical, mental, and moral integrity respected, and not to be subjected to inhuman or degrading punishment or treatment. So that right basically means that everybody should be treated with basic dignity and respect. And also the Article 22.1 right to move about one's state or country and to reside in that state. So that basically means that nobody should be either restricted from moving freely about the state in safety and security, or forced to in some way leave the state, as Gareth and Simone both had to do for their own personal security. And the Commission noted that the mere existence of the buggery and gross indecency laws provide a social sanction for abuse and contribute to homophobia against all LGBT persons, and therefore violate those rights to humane treatment and freedom of movement and residence. The third cluster is the Article 9 principle of legality. So the buggery and gross indecency laws were held to violate the principle of legality because they criminalize conduct that is recognized as protected in international human rights law. So while it's up to any state to decide what is and isn't a crime, states shouldn't criminalize human rights protected conduct. And lastly, the Article 25 right to effective judicial remedies for people who allege that they have been the victim of human rights violations. And that's also under the rule of due process in Article 8 of the Convention. So for a remedy to be counted as an effective judicial remedy, it's not enough that the remedy exists on the statute book. It must be practically effective as well and provide a real opportunity for redress. And the Commission found that even if it's possible under Jamaican law to submit a domestic challenge under the Constitution to the buggery and gross indecency laws, that savings law clause that I mentioned earlier means that there's no real remedy or ability to get those laws struck down for a violation of the human rights provisions and protections in the Constitution. So Jamaica was found to have violated the right to judicial protection. Based on all of those findings, the Commission made several broad recommendations and quite sweeping recommendations. Firstly, to provide reparations to Gareth and Simone for the human rights violations that they suffered. Secondly, importantly, to repeal the buggery and gross indecency laws. but then much more, to enact legislation to prohibit discrimination on the basis of sexual orientation or gender identity, to collect data on the prevalence and nature of violence and discrimination against LGBTI people, to ensure all allegations of violence are properly investigated and prosecuted. And then in the education and training sphere, to increase LGBTI awareness training for public officials and to provide gender and sexuality education in schools in order to modify these long-standing social and cultural patterns of harmful behavior. So that's a very quick summary of the case. And in terms of its impact, I'll just close with, obviously the important point, as Gareth mentioned, that the Commission cannot force Jamaica to comply with its recommendations. But despite that, the decision has at least 4 really significant impacts. Firstly, and foremost, perhaps it vindicates the rights, experiences, and suffering of Gareth, Simone, their families, and all LGBTI Jamaicans, and makes clear that the Jamaican state is responsible for everything they've been through. And that's really powerful. Secondly, it's the first decision of its kind in the inter-American system on the issue of decriminalization. So it has made groundbreaking new international law for the entire region of the Americas that now sits alongside other international cases such as Tunin at the UN, and the Dudgeon, Norris, and Medinos trilogy of cases at the European Court of Human Rights. Thirdly, it provides another source of pressure on Jamaica to finally repeal these laws criminalizing LGBT people and to take other measures to protect LGBTI people. And lastly, it will be used in many other domestic cases that are ongoing across the Caribbean region to help domestic courts come to the right legal conclusion and strike down similar anti-LGBT criminal laws. And there are several of those cases ongoing at the moment. And this case will be cited in all of those cases. So I will leave it there. Thank you very much. Happy to answer any questions afterwards.
Thank you very much, Taya. That was exactly on time. And I want to use this opportunity to encourage participants to start putting questions, any questions you might have for the panelists in the Q&A box, because we're going to be moving to Q&A very quickly. But thank you very much, Taya, for that very general overview of the decision of the Commission. One thing that struck me about the Commission, and it's something that's a very contentious issue in this area, is the idea of human rights bodies, international bodies, imposing foreign values, imposing foreign laws on sovereign states. One of the things that was very interesting about this decision, that not only did the Commission draw on cases from Europe, from international human rights bodies, but also from courts in the Caribbean, including the Supreme Court and Court of Appeal of Belize and the Supreme Court of Trinidad and Tobago. So we've moved leaps and bounds from the time that this petition was drafted, when there was no jurisprudence in the Caribbean. But what the Commission was doing was holding Jamaica not only to its international obligations as interpreted by the international community, but also by member states of CARICOM. So that's a very interesting development, and it's going to change, I think, the discourse around these issues, because this is no longer an us versus them discussion. It's about us as Caribbean people and Caribbean governments and the courts in the region increasingly recognizing this area of rights protection. But without much ado, let me now turn over to Glenroy, who's going to speak about the impact of the decision and the very important work that's left to be done in implementing it and leveraging it for good.
Thank you, Conway. I think when we think about the impact of this decision is I go firstly to the recommendations, like the work that JPAC has been doing since about 2016 broadly looks at different areas of law that needed to be addressed. So yes, these boundary laws are bad. Yes, gross indecency laws are bad, but we also need protective laws within the country so that the experiences of a Gareth and a Simone does not occur with impunity. And the mere fact that the Commission went as far as to recommend anti-discrimination legislation was something we were very happy with, because it's something that we as a community have been asking for and have been engaging the government around already. I think before I kind of go further, I think it's important to kind of say to Gareth that, you know, it's really unfortunate that a lot of that happened to you and many of your contemporaries. But I would hope you take solace in the fact that, you know, activists like you walk so I could strut. And so the work that I'm able to do today occurs within the context of growing out of shining a light on a lot of what happened to a Gareth and a Simone and many persons like that. And we try to continue on that kind of work and bring attention to the level of violence and discrimination that occurs in Jamaica. There hasn't been an official reaction from government since the decision. I optimistically am hoping that because of COVID and other recent happenings that, you know, they haven't gotten to it yet and that it's not an intentional silence, because what the decision does is give us an opportunity to talk about a range of options of how do we address this issue, this long-standing issue of criminalizing LGBT persons, but also having a law in place that discriminates against the population en masse. I think, unfortunately, our government has had the habit of saying we do not discriminate in law against the LGBT community. And now we have a clear decision that says, but no, the very existence of a law like this does that. It does discriminate, even if it doesn't say it's illegal to be gay, and even if it doesn't say, you know, even if it focuses on a particular kind of conduct. And I think that's a starting point to have the conversation. We've made recommendations in a 2018 Joint Select Committee process to have the law repealed. And the report, unfortunately, kind of scapegoated, I think, and didn't make any kind of recommendations one way or the other around addressing the anti-sodomy laws. And there has been talk leading up to that point of a referendum, and I don't think currently it's been pursued, but it was mentioned in the only comment that a government official made on the case. And that is not something that as a community we're interested in. We're not particularly interested in using a referendum to address the anti-sodomy laws, given what the research shows are the current sentiments around the Buggery law, given that for one reason or another, the Buggery law has become some symbol of national identity. And so we want to work with the government to kind of unravel that notion that Jamaica has become defined by its retention of the Buggery law. Because for a country that equally, you know, has said recently in the Universal Periodic Review that it wants to address violence and discrimination, it must now recognize that the Buggery law is antithetical to that violence and discrimination, and that there has to be some work not just to address this law, but to protect LGBT Jamaicans from the widespread nature of the violence and discrimination, and to do the work of promoting anti-discrimination in many spheres of life. There's a reticence, I think, because of many different actors, including right-wing members of the church who continue to perpetuate very outlandish stereotypes of the community and misrepresent what the community wants. And what we're trying to do, and what we hope to do with this decision, is to kind of add it to the, as you would have acknowledged, Conway, the corpus of cases that says these kinds of laws are a problem. They no longer fit within a Caribbean context. Belize has said it, Trinidad has said it. And so Jamaica, who prides itself on being a leader within the region, needs to make a clear decision on how it chooses to represent itself in the new era. We're having a lot of conversation about how we define ourselves. I mean, we're also talking about abortion at the same time. And I think it's important now that we recognize that this decision allows us to look inward and do the necessary work. And so I think And I'm hoping that it's another reason for them to engage us. And they have engaged us, and I'm not going to not acknowledge some small steps that they've made. The National Youth Policy, for example, prohibits sexual orientation discrimination. And in 2011, the JCF, which is a police, their force order prohibits sexual orientation discrimination. And there's a public sector staff order that also prohibits sexual orientation discrimination. But we need to move from policies to laws. And the decision recommends that. And so we need some very clear action from the government. We need to move from statement to action. And the government needs to recognize its role in moving the society along, so that the attitudes can begin to change, their awareness can begin to change. And the community has been engaged, and we have a good relationship with some parts of government, but that needs to be a standard. It needs to be understood that your LGBT identity doesn't take away from the obligation of the state to you. And that's the hope going forward, that the decision underscores that responsibility that the state has towards the LGBT community, and underscores what should never happen again, or the kinds of and the severity of violence that should never happen again. And or to phrase it differently, what happens when the state is derelict in its duty towards a certain section of society. We don't want more Gareths and Simones in terms of what happened to them. And I hope in time that the government formally engages us about how do we discontinue that from happening.
Thank you very much, Glenroy. I think it's important for us to acknowledge, as Glenroy has done, that this case is, it plays two roles. It memorializes certain very horrific episodes in the lives of Gareth and Simone. And if you read the decision, you see in very graphic detail the telling of the trauma, the abuse, the violence that they have suffered. And it is representative of, I think, the violence that has been suffered, mental and physical, by many Jamaicans over the years. But also we do recognize that Jamaica has moved, has been making steps in the interim period, including because of the sort of consciousness raising and the very, very, very good work that JFLAG has been doing to make incremental steps in policy. But as Glenroy very, 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 very clearly says, policy and staff orders, which, by the way, I think the Jamaican government did raise in the context of its reply, its technical reply after publication up to the petition. But that does not obviate the need to address the laws. And one of the very important contributions of this decision, I think, is to recognize the centrality of the law in building identity and in building a culture. And as you rightly say, Glenroy, it's seen as representative and constituting of Jamaican identity. And so I think one of the things that this decision does, which is kind of unlike the decisions we've seen in other parts of the world, it recognizes the central symbolic role of the law, which suggests for us that getting rid of this law may be one of the key requirements for moving on culturally and socially and to building a more inclusive society. I'm going to just take Chairman's prerogative and just ask two short questions and move to the questions that have been piling in. Tia, I mean, a very great decision, but is there anything that you wish could have been addressed? I noticed the lack of any statement as to freedom of expression. Where are we with that aspect of the law? Just very briefly.
Yes, this decision doesn't reference that, right, but it's a really interesting point, and one that is only just getting developed in law internationally. And in fact, another case from the Caribbean region, the Caleb Orozco case in Belize, is one of the first two anywhere in the world to recognize that these types of laws also violate the right to freedom of expression. So the Orozco case, which was decided in 2016 and upheld on appeal in 2019, that question of freedom of expression was a specific point that was challenged on appeal, and the court upheld the finding of the Supreme Court that these laws do violate freedom of expression. And similarly, the Indian case, Johar in India, that was decided in 2018 at the Indian Supreme Court, finds that amongst many other rights that are violated by these laws, freedom of expression is included. So those are the first two cases anywhere in the world that recognize that freedom of expression is more than the right to speech and those types of typical expression, but also include sexual expression and choice of a sexual partner. So that's incredibly groundbreaking as well.
Well, this is obviously a very fast-moving and evolving area, and so we watch with interest to see how the jurisprudence develops. I'm going to move now to the questions, and a great many of them. And I'm going to start with one from Brent Hawks, which asked the question, what role did religious opposition play in the process leading to this decision? Was there any religious support?
Sorry, who did you want to address that to? Was that addressed to anybody?
Anyone who has any
okay, well, I'll just say that there was no religious involvement in the case itself, in the sort of legal process of the case. Glenroy and Gareth will obviously have lots to say about the role of religion in the context in Jamaica, but in terms of the legal process, there was no role or played by religious leaders.
Then I want to, the piece I add to that is that, without fail, the religious organizations and churches in Jamaica never cease to be oppressive towards the gay community and continue to preach hate, which helps to intensify the challenges that LGBTQ individuals experience in Jamaica. So, their role is clearly defined. Which counter what they then teach beyond the pulpit as it relates to loving your neighbor as yourself and brother love and that kind of stuff. So it is that kind of a contrary. Anything that has to do with homosexuality is meted with fire and brimstone from the church, and they publicly state these theses. And I think a part of the fact why that our political leaders tend to be a bit timid, and this is where it's also important for religion and state to be separate, is that the religious organizations in Jamaica are very influential as it relates to our political leaders. They're involved in everything that happens politics-wise. The church is there, on those kind of conversation, and they oftentimes are consulted more than civil society, right, and other civil groups in Jamaica around rights and human rights and that kind of stuff. And so, there's no political leader right now, I think, would dare stand up against the church to say, no, we're going to repeal sodomy laws. It was like, and the church have threatened our politicians in very different ways. Say, you dare not touch those laws, and so our politicians are timid. That's how, and these religious organizations are funded and supported by all of these fanatics across Europe and across North America. They are well-funded, well-resourced to fight to maintain the sodomy laws in the books. And these are funding coming through the US, coming from Canada, coming from and other parts across Europe, right? And so they are well-grounded and well-supported to make sure that the sodomy laws are not repealed. And so I feel our government, the government's hand tend to be tied because there need to be a clear separation between church and state.
Yeah, just to kind of echo that, you hear it anytime there's a dialogue around LGBT issues locally. I mean, even as I'd like to think that sentiments ease and become softer, you hear them saying, but if you touch that law, you will see what happens. And on more than one occasion, they make very plain that threat. And even now, as we discuss the abortion issue, you see them out in full force, And I think if we think about the new savings law clause, because as Taya mentioned, our charter was amended in 2011. And when you saw the specific laws, because we used to have a broad savings law clause that prohibited all existing laws from being reviewed. And they then specified sexual offenses, abortion, and obscene publications. So I think you could very clearly see the organizing of the church in ensuring that certain laws were stayed on the books, or at least did not end up in Jamaican courts.
It's interesting, Glenroy, because one of the replies that the government has made, and it hasn't made very many sort of responses, certainly didn't turn up on the merits, which I think is disappointing or speaks volumes, is that it says that, well, you know, LGBT individuals do have recourse to constitutional redress. You don't have to challenge the laws, but you have a general right to constitutional redress for any violence, etc. Well, I think that misses the point when the very Constitution itself, and they point to the Charter of Rights, when its own enactment was quite ironically not an enactment I suspect that on average, Jamaicans lost rights with the enactment of the Charter of Rights on average than they gained rights. Because, for example, of the very ad hominem attack on Tunen, the fact that they specifically immunized any challenge on the basis of sex, the fact that they gerrymandered the savings law clause. I think it is not very persuasive for the government to then point to the Constitution and say that that is a document to which people, sexual minorities can embrace and think gives them full protection of the law. So very interesting, the North Americanization of the politics around religion and how that is impacting on decisions in Jamaica, in the legislature and government policy. I want to clump a number of questions together because they follow a similar theme, and it's about compliance. And of course, you know, we are, you know, we're taking in the decision and really happy about it. But the next question is compliance. As we've said, it's not binding in a strict sense. It cannot be enforced in any court in any direct sense. We do know, however, that inter-American decisions have been very influential and have been persuasive in the Jamaican and Caribbean courts. But what is the idea about how we're going to be seeing compliance? How can we encourage compliance? And particularly, Glenroy, as you speak about working collaboratively with the government rather than in an antagonistic fashion.
I think, all right, so, you know, because of the notion of foreign interference, as you would have rightly acknowledged at the start, the notion of external pressure doesn't work. I think people often like to point to the Stop Murder Music campaign for a lot of the shifts that have happened in dancehall locally, and that's a part of it. But then what happened locally is that they doubled down on the homophobia in their music. So I think what needs to happen is a kind of, at the international level, an engagement of parliamentarians, a kind of parliamentarians engaging other parliamentarians on how can you start to begin the work of addressing human rights. I think there's a lot of fear there, and I think learning from each other in a non-combative and a non-accusatory way may work. And for us, and encouraging them to engage their civil society more. I think that's what the international partners can do, because I think that's also a popular question, you know, what can we do to help encourage our leaders to engage civil society a little bit more? And I think compliance will come from that engagement, and it will come from us kind of supporting them in different ways, and also providing support to communities to organize, because I think what Gareth rightly points out is that we need to be just as organized as our opponents are. And I think that that's a part of the challenge, is that the kind of, you know, funding and support isn't always there for us to organize in ways that they can organize in.
We've also had questions about what the sort of record of Caribbean states are with responding to inter-American petitions. Now, I mean, I can add a little bit on that, because we know that the only sort of category of petitions, I think, that would come close to this in terms of its contentious nature is death penalty cases. And we know that when the death penalty cases were decided in the inter-American system, it took a long time for them to trickle through, and the death penalty is still on the books in Jamaica. However, with certain modifications, which mean in effect, it is very rarely, if ever, sort of issued as a sentence and almost never carried out. That is a very good parallel as a decision which seemed to have coming into contact with another issue in the criminal justice system that seems to be held up as a form of identity. Is there anything that we can learn from the death penalty experience in thinking about a way forward in getting this decision used as precedent, being leveraged in other litigation, or just generally in ensuring human rights compliance?
Just quickly, I think, so back to the charter, section 13.8 actually tries to undo some of the strategic litigation that was done around the death penalty. And I think what that teaches us is that law reform is not enough and strategic litigation is not enough. And that what the commission recommends in terms of doing a campaign, going in schools and educating around inclusion and tolerance, that has to run concurrent to that, because what you do not want is with one, swish, all of the work that has been done to be undone. And I think what happens in America is useful to think through that, policies and laws can change, but they can be pushed back. And how we deal with pushback is by making sure that there is that grassroots work, that there's that work at the level of changing hearts and minds, and that there's continued support for that level of changing hearts and minds.
Okay, thank you. You rightly say, changing hearts and minds, I think, is perhaps where it is. Or, it's not even changing hearts and minds. It's having citizens and the society recognize the constitutional values and human rights of all individuals as equal, or as Gareth very eloquently put it, forcing Jamaicans to live up to their national motto, which is that all out of many, one people. It's a country that is built on an ideal of diversity, and it's holding Jamaicans and the government to account with that very lofty ideal. But in the area of compliance, obviously, it's an international decision. There will be there are questions I'm seeing here about how can activists and actors elsewhere encourage the government or encourage compliance. We do know that Jamaicans are very proud people. They do not like to be told what to do. So how would we encourage those who are well-wishers of the country, well-wishers of the community to assist? What would be most fruitful in seeking to encourage dialogue on this and the type of sort of compliance that is necessary?
All right. So trade sanctions won't work. So let me just clearly, because I saw a question about that. The forceful responses will not work locally. Even if they position themselves well internationally, they won't work locally. And so we have to kind of think through finding champions within private sector as well, because also our government listens to our private sectors, and having those, and within international development partners, and having them engage governments about how they can start to do that work as well. So I think it's supporting the local communities and building them up, because JFLAG is one entity and you need more JFLAGs to add their voice to the call. And when the leaders are in the international spaces, in so much that they will be post-COVID, engaging them in different, and as I said, not confrontational ways about living up to the name that Jamaica and living up to the motto.
I oftentimes, and will always maintain, I have a different, a mixed opinion on these pieces, because again, of my lived experience and because of my work with Rainbow Railroad, because of the horrific stories I hear every day, right? Because something has to give, right? That's what's the bottom line. Something has to give, and You know, I've been involved with like with the movement. I came up when JFLAG was founded in 1998. I was there. I was been involved from that time, right? And you know, and the prior to that, the gay freedom movement, all those stuff, and it's oftentimes it's years in the making, and we've always said the same things, right? We always want to hold to the piece that, you know, the external pressure it has to be crafted a particular way, all that kind of stuff, and the hundreds of lives that have been lost, you know. They go back to say like this year, just starting this year alone, the request for help that we get from Jamaicans through Rainbow Railroad from Jamaica alone is in excess of 1,000 people, right? I talk to literally every day over 30 gay, lesbian, and trans persons who are traumatized, who are victims of homophobic violence, right? Persons who I've worked with who have committed suicide because JFLAG couldn't have, Rainbow Railroad couldn't have helped to move them immediately, right? And they just can't hold on no more. It's so severe, it's so painful, right? Women, lesbians who have been raped, and it's because the issues around gay men tend to be sensationalized, right? And so something happened, it's all over there. But there's a shame for women or lesbians or sisters who experience that trauma and can't come out publicly and talk about that. There's a shame with that where that is concerned. Raped multiple times in severe abusive sexual relationships because of again, you know, family members, and this goes on. And we continue to talk. We continue to hope that on the ground with civil organizations and mobilizing and doing something, that we will eventually get the ear of the Jamaican government and something will happen. And so I have mixed emotions and mixed reactions to it, because it's the cry is dire. Something needs to change. And I always believe that Jamaicans and the politicians are stubborn. We have to realize that the cards are so stacked against us that there is, no matter what JFLAG tries, no matter what the community tries, the deck is stacked against us, because more people are being killed, more persons are being displaced, because and the inroads have been made. I hear says the pieces in Glenroy, some of the spots are stuff that has been happening, has been changing, that kind of stuff, but at what cost, right? And what has happened since then is, you know, does that translate into behavior change and attitude towards LGBTQ people? It doesn't. It doesn't change that, right? And so, you know, I believe, and I will always say, international pressure is important. It requires organizing. It requires, you know, engagement and conversations with the local organizations on the ground, the activists being engaged in meaningful dialogue and conversations and having some good discourse around, let's develop a strategy. Let's do something. Let's work together. And it can't be at one end. I always say this, you know, at one end, you know, we look to the international community, but then on the other end, was like, no, you know, here's a pause, and this is a line that we don't cross. Human rights is human rights, universal. It doesn't matter. It's a world that we want to create in which all people are treated equal and treated fairly. And I believe if I can get support, as I did get the support from the Human Dignity Trust and other international organizations and group and advocates to bring forward this petition, right? I couldn't have, you know, that is a kind of a structured support, and it worked. Right now, we have some very good recommendations to stand on. The reality of it is now what's next, right? The piece with how will JFLAG use this information to work with other organizations, other international organizations, because JFLAG can't do it by themselves. But it needs that coordinated support. So, you know, stemming here from this today's conversation is that ongoing conversation, that commitment from JFLAG and other activists in Jamaica and across the Caribbean to say, okay, how can we operationalize this? What does this look like? What are some of the things that we can? But we can't keep saying the Jamaican government and Jamaica is opposed to international pressure. Just note that the international community, through these religious fanatics, are fueling this hate. And so the reality of it is that what are we going to do? We can't do this all by ourselves as Jamaicans. We have been trying this for many years. Many years we have been going at this at the cost of hundreds of lives and people who have been silenced because of their sexual orientation and displaced because Jamaica can no longer provide them protection and support. And so it requires conversation, a strategy need to be developed. I see a question around there from Eagle, asking what can be done given the role I can't explain, is JFAG being open to these discourse and conversations, working and building partnerships to operationalize and to do something in a meaningful way. And it's again, this homosexuality, as when growing up as a kid, often that experience that is something that is exported from North America and Europe to Jamaica. It was like, it's their thing, it's not our thing. And the reality of it is that it is more our thing than anything else. It's our thing. We are a part of the fabric of that diverse community that exists within the world and throughout the world, and we have to. JFLAG and Jamaica and activists across the Caribbean, we have to find that common ground where we can have these meaningful conversations, so no more lives are being lost. No, you understand? No more people, no more Gareths have to run away and seek refugee protection and become displaced in a foreign country. It is not right. And we have to always remember is that as we traverse this world, that we all want to be safe. We all want to feel protected. And so if we can't do this as a collective, then it makes no sense, right?
Thank you very much, Gareth. I think we're almost out of time. We're almost out of time, but what Gareth's exchange with Glenroy shows is the complexity of the task and the enormity of the task which faces activists and those, not really activists, all those who are committed to equal human rights for all individuals. Human rights compliance is an issue of politics, international politics, domestic politics, and as such, it's very complicated, and a lot of hard work has to be put into thinking about how we can leverage these decisions to ensure that governments are brought to account for their actions and for failure to protect their citizens. But we shouldn't let the enormity of the task which faces us undermine the very significant achievement that has been obtained after a decade of very hard work. I must say that as someone who studied the law and studied human rights in the Caribbean, I would never have thought that if you told me that Caribbean courts and the inter-American system would be issuing judgments and decisions of this nature. I would never have thought that the Jamaica Constabulary Force would have staff orders, or there'd be policies in line with what we understand is developing on foot in Jamaica. So it is obviously, as with all issues of human rights, a story of hope and a story of continued struggle. But I want to thank everyone for joining us. I want to thank everyone again who has been involved in this very important case and this very, very hard-fought battle. To Gareth and Simone, to Glenroy and all the activists and people on the ground fighting the battle day after day, to colleagues at the Human Dignity Trust, to the various pro bono lawyers and supporters and funders throughout the world and well-wishers who have been working tirelessly for the fight for human rights. Unfortunately, I have not been able to answer every question or to get every question, but of course, the dialogue continues. So please feel free to reach out to panelists, to reach out to members of JFLAG, the Human Dignity Trust, Gareth, myself, if you have any ideas and if you want to exchange any views on this case and the very important work that those on the panel continue to do. Thanks again. And if there's nothing else from the panel, I think we're going to wrap up.
Thank you, everyone. Thanks, Conway.
Thanks, everyone.
Thanks, everyone.